Hello, welcome everyone to another edition of the SSLT. We're very lucky to have with us today Professor Jesse Wall from the Faculty of Law, University of Auckland. So for those of you who don't know him, he's interested in the methodology of the philosophy of law, private law theory, and criminal law theory. And his main works include monographs published with Oxford University Press. Being and Owning was published in 2015, and Sex and the Other is forthcoming. Jesse is talking to us today on normative powers and the pro tanto wrong thesis again. So without further ado.
Great, thank you, Ivan. And let me start by extending my thanks to the NUS Centre for Legal Theory and for Andrew Halpin so kindly hosting me today. It's a pleasure to be here. I have a colleague at the University of Auckland who tells mythical stories set a long, long time ago in a city-state far, far away. And it's nice to be here in person and to meet you all. So my sincere thanks for joining me today to discuss this work in progress, which is part of a larger project that I'm working on. And I look forward to your comments and questions and criticisms once I have a chance to set this all out. So let me start by introducing this topic that we're looking at today that I've labelled normative powers in the pro tanto wrong thesis again. About 8 years ago, I wrote a paper called General Reasons Not to Have Sex. I assume it wasn't widely written because I think those who were sexually active continue to be so. But it nonetheless snowballed into a larger project for me. And so I'm working on a book called Sex and the Other, where amongst other topics, I'm defending this claim that has become known as the pro tanto wrong thesis. The pro tanto wrong thesis is about how we structure sexual offences. So according to the pro tanto wrong thesis, sex itself ought to be considered a wrong that the provision of consent can justify or excuse. And so, according to those few of us who defend the pro tanto wrong thesis, it is the provision of consent that should be a justificatory defence rather than the absence of consent being an element of a sexual crime. In today's discussion, I'd like to draw a connection between two main sets of ideas. One set of ideas is the ideas that pertain to defending the pro tanto wrong thesis and the perennial criticisms that the pro tanto wrong thesis attract. But I also want to discuss the idea of normative powers. Now, these normative powers relate to our ability to curate the obligations that we owe other people and the obligations that they owe us. So it's the ability to control and change our normative situation. In particular, our normative powers include acts of promise-making, of forgiveness, and of consent. And are the three that I want to start off by looking at how promise-making can generate obligations upon ourselves, how forgiveness can waive remedial obligations that are owed to us, and how consent can suspend or forbear obligations that would otherwise be owed to us. And the hope is, with this paper, that by locating consent within the context of normative powers, I have the resources to better defend the pro tanto wrong thesis. So these are the three main questions that I want to focus on today and try to provide a somewhat contained discussion. So the first question I'll ask is whether or not our normative powers are reducible or can collapse back into what I will describe as non-normative interests. The second question I want to focus on is whether or not the content of consent is morally fundamental or whether or not it just depends upon social convention. And then the third question I want to focus on is this idea of residual regret. So one of the main objections that people raise to the pro tanto wrong thesis is that sex itself cannot be a pro tanto or prima facie wrong because when we engage in sexual activity that's consensual, we have no reasons to regret it. And that is one of the three objections, but the one I wish to focus on today. Now, these three ideas relate, as I mentioned before, to a much larger project. So you'll see that today we'll be talking about normative powers, the contrast between foundationalism, conventionalism, and ideas of wrongdoing, culpability, and regret. But these relate to broader questions that I'm trying to address in my book, Sex and the Other. You'll see the first question relates to a question of methodology that I'm still grappling with, and I hope to sit at your feet tomorrow to discuss whether or not we have reasons to hate and despise legal philosophy when it's done in its traditional analytical manner. But you'll see within the long list of questions and chapters in Sex and the Other, there are questions about pro tanto wrongdoing, regret, consent, and conventions. So hopefully these three main questions will be self-contained, but it may mean we wander off into larger and broader ideas that may be equally interesting. So in terms of today's presentation, I'm going to move through three main parts. The first is I want to set out why normative powers are interesting and relevant to questions of consent. And largely I'm going to create a distinction between non-normative interests and normative interests that I then rely upon later on in the discussion. Similarly, in part two, I'll draw a distinction between different counts of normative powers, being in foundationalism and conventionalism. This means that we can start pulling apart ideas of consent and choice, which helps us understand how normative powers operate in a way that doesn't collapse back into what I term non-normative interests. But that gives us the resources to then look at the pro tanto wrong thesis again. And after giving a brief overview of what the pro tanto wrong thesis claims and is about, I then return to three perennial objections to the pro tanto wrong thesis. The idea that there's nothing wrong with sex per se, that there's nothing culpable about sex per se, and there's nothing regretful about consensual sex. So let's then start with the idea of a normative power. Now, we may be familiar with certain practices that we engage in where we try to control our normative situation, where we make promises, where we forgive other people, where we consent or permit. And that has the effect of curating or controlling the obligations that we find ourselves in and the way in which we relate to one another. Now, as familiar as these normative powers may be, they may themselves be powerless. So there's a long tradition of questioning whether or not merely someone's will coupled with their intention can change the moral status of an object or even an obligation. And this, I doubt, can be traced back to Hume, who held it to be mysterious or comprehensible that certain words along with a certain intention changes the entirety, the nature of an eternal object and even of a human creature. So it's at least curious that a mere declaration of an intention can bind me with promissorial obligations, or that by me communicating my forgiveness I can erase or change a wrong, or that my expression of consent can render something permissible that would otherwise be impermissible. Now, one way to understand how normative powers work and how they have normative content, or moral content I should say, is to collapse them into our non-normative interests. And here I want to introduce a distinction that I'll rely upon throughout this discussion, and that is distinction between normative and non-normative interests. When we talk about non-normative interests, we're concerned here with the moral interest we have in controlling our natural or physical phenomena. In comparison, normative interests have a different object upon which they act or they focus upon. Normative interests pertain to normative phenomena, the idea of wrongs or obligations. And so one way in which we could explain normative interests is to say they are just the combination of non-normative interests. So our idea of having normative power just collapses back into the interest we have in controlling our situation, our physical scenarios. And so in the context of promise-making, forgiveness, and consenting, we can see that one way of understanding why it is it's wrong to break a promise is because that causes a harm to someone's non-normative interests. So the obligatoriness of performing a promise, we might say, does not come from the expression of intention, but from the expectations held by the promisee or the reliance expended by the promisee. The declaration of the promise itself just triggers the potential for harm, and it's those harms that can explain the wrongfulness of breaking a promise. We can also explain the normative power of consent in the same way, that it's not the declaratory act of consent or permission, but it's the fact that unconsented activities are also unwanted, unchosen, and thereby harmful to that person. But collapsing our normative interests into our non-normative interests does require us to adopt a particularly narrow view of something like forgiveness. And we can just view something like forgiveness as being redemptive, by which I mean forgiveness might just represent the acknowledgement of someone fixing their wrongdoing. That where a person has harmed you and they have compensated or annulled your loss, forgiveness might just be acknowledgement of that compensation, of that annulment. And so here, forgiveness, like our previous account of promise-making, is locating the moral force in the harms done by another person or the harm suffered by another person, rather than in the choices or agency of the promisor or forgiving person. Now, if we're not satisfied with collapsing these interests, we could try to isolate our normative interests. And one common tactic of isolating our normative interests from our non-normative interests is to talk about bare wrongs. Now, a bare wrong is an act that is wrongful only in the sense that is contrary to an obligation without directly harming any non-normative interest. So, for example, I might promise to you that I will get you a ticket to a concert, where in this scenario you have no interest at all in attending the concert. In such a situation, you might feel that I have changed the normative situation between you and I because I have made a promise to you. But if I break that promise, I haven't harmed any non-normative interest because you'd gladly miss out on whatever musical or artistic experience was at hand. So it is entirely harmless and inconsequential, and yet still a bare wrong. It may be trivial, it may be minor, it may have very little weight or gravity, but a bare wrong it is nonetheless. Similarly, another example in terms of consent or permission, I might email you to allow you to use my pool whilst I'm away this summer, but as it happens, my email is left in my outbox. Now you may presumptuously use my pool over the summer. You've not harmed my non-normative interests, and yet you still may feel that you have wronged me. You have acted without my permission. So we can isolate or at least retrieve the idea of normative powers by latching on to the idea of bare wrongs being a genuine, if not trivial, wrong sometimes. But it also helps us broaden our understanding of forgiveness. That we think forgiveness is more than just the acknowledgement of a wrongdoer's acts of reparation or compensation. That forgiveness is an exercise of choice and agency by a forgiving person. And that's because forgiveness, I suggest, is also an act of waiver. It is the ability to forego obligations that would otherwise be owed to you. So when someone's wronged you, you might have a right to annulment, you might even have a right to resentment, but when you forgive someone, you forego those rights. And that's because forgiveness is not just the mere acceptance of a normative situation. It's not just acknowledging that someone has fixed their wrongs. Rather, it is the exercise, it is a decision to change your normative situation to forego rights you would otherwise have. So far I've tried to isolate normative interests from non-normative interests. But we haven't explained the initial puzzle or the doubt that human others have as to why we have normative interests, even if we can isolate them. Which takes us on to a second set of ideas. That is the distinction between foundationalism and conventionalism. So one way to understand why we have these normative powers why we have the ability to make promises, forgive, permit, or consent, is because they express something that is morally fundamental about our situation. That is our will to be bound by a promissory obligation. It is some kind of choice to forgive or to waive a remedial obligation. Or it's some kind of intention to involve another person in interaction through consent or through permission. And so we might treat these normative powers as somehow morally fundamental. In which case, acting contrary to obligations that normative powers curate or generate represents a fundamental moral wrong. A competing account is to say that what these obligations are ultimately morally discretionary. That we engage in these practices because we are engaging a social practice that has been built up around us. And that means that whilst these obligations depend upon a shared social practice, they still represent genuinely moral tools to improve our situation, but the moral wrong in acting against the obligations that these normative powers create and generate is wrong because we are misusing or eroding or damaging what is a morally valuable social practice. So theorists of contract law will find this tension to be familiar between competing accounts of those who try to explain contract as morally fundamental in terms of promise-making, or the conventionalist account that identifies the harm of breaking a contract in terms of undermining or eroding a morally valuable social practice of voluntarily assuming obligations to other people. Now, we might think that something like consent, especially consent to intimate activities such as physical interaction and sexual intimacy, is fundamental. That it somehow speaks to the expression of our agency, our preferences, and our interests, and so on. And that may be true. But I also want to pull out an aspect of consenting or permitting that is also conventional. And to do so, I want to draw a distinction between consent and choice. Now, consent is going to be the exercise of a normative power. Consent involves the waiving of an obligation that would otherwise be owed to us. Choice, or the language of choice that I'm using here, is different. The significance of choice reflects the interest in controlling what is done to us. Now, that is going to be a non-normative interest because it speaks to our situation and the physical phenomenon that we encounter with. So whereas consent has obligations as its object or focus, choice is going to have a non-normative object. It's going to be about our bodies, or about a book, or about a swimming pool. Now, all things going well, we would expect consent and choice to align. But we can try to pull these apart. Now, David Owens, in Shaping the Normative Landscape, gives us 3 examples to try to untether consent from choice. The first example speaks to a circumstance where you're giving a lecture or a presentation at a conference that has parallel sessions. And here he describes a scenario where you begin your talk by announcing your name and topic and inviting those who are there by mistake to give them the opportunity to leave the room. Now, he explains in that context, people who leave the room are doing so without wronging you, because you have suspended or waived any obligation that might be under to continue with your seminar or session out of respect or courtesy. So here, David Owens suggests that you are granting permission for your audience to leave, you are suspending an obligation on them to remain, whilst you do not want them to. It will not be your choice, it will not be your aim, it will not be your hope that the entire seminar audience leaves. But the departing audience do not do any wrong to you because, again, that obligation has been suspended. Now, we can, if we want to, try to show that there is an element of choice aligning with consent that I mentioned in the paper. In the second and third scenarios, we start seeing choice and consent pull apart further. He explains that there are scenarios where we might invite someone to a party where we do not want or expect that person to show up. And so you're giving that person the right to attend without any intention or hope, choice or desire that they do so. And in the third scenario, we have the inverse. where you might communicate an intention that someone would attend a party. You may choose for them to attend, but you do not consent. And in his scenario, he describes the need for someone else to invite them because of some kind of falling out or social circumstance where there needs to be reconciliation between someone before someone can come to a party. So these examples are used to try to pull consent away from choice, to try to differentiate the normative power we have in suspending obligations as different from the choices we make to control our physical environment. Perhaps more vividly, Robin West has recently written about what she calls hedonic dysphoria, which has a similar structure to it. She explains that when it comes to sex, the focus of lawyers and philosophers alike has been on consent and not choice, or what she refers to as motivation. And her concern is that this ethic or focus on consent means that sex is now widely insulated from criticism, so as long as it's consensual regardless of the motive that triggered that consent. So this means that if we focus on consent, we're no longer interested in the choices that motivate that. Which means that not only do we have sex for pleasure, but also sex for survival, sex for exercise, for money, for diversion, for release from stress, from entertainment, as an expression of friendship, as an expression of any other impulse, is equally insulated from critique as long as it is consensual. And she explains in that paper the harm that is occurring where many women and girls and some boys and men likewise often or routinely consent to sex when they neither desire, want, welcome, or find it physically pleasurable. So the point of these four examples is to try to consent away from choice. And we can start pulling these concepts apart because the normative work that consent can do is limited. All it can do is declare that someone is not wronged if an act were to occur. So the normative work of consent is to declare that a person will not be wronged if sex were to occur. It cannot speak to the other factors, the non-normative interests that people have in controlling their physical environment when it comes to physical or sexual intimacy. The point for now is that normative powers are limited. They are transformative, but they only transform the normative situation. They only act upon normative phenomena of obligations and wrongs. It cannot address the all things considered moral situation. And that's because choice and consent have different objects which they act upon. We can permit activities that we do not choose or desire, and that's because this distinction between the normative powers and our non-normative interests. But in pulling apart consent from choice and normative interests from non-normative interests, does not yet address the underlying doubt as to whether or not normative powers have any moral content to them. So to address Hume's doubt that we started this conversation with, let me make two main ideas. The first idea answers this question of why it is we have these normative powers even when we can use them in a self-defeating way. So David Owen's example of the uninvited guest, or the unwanted guest, I should say, or Robin West's example of routinely consenting to unwanted physical or sexual intimacy, illustrate this puzzle that why do we have these normative powers if they are self-defeating or self-denigrating? And the answer to that question lies in the value that these normative powers can create when they do align with our choices and our motivations and our non-normative interests. That it's difficult to contemplate a morally sufficient or morally adequate life without the exercise of these normative powers. Without these normative powers, we have no ability to share a physical space whilst retaining control over it. We'd be unable to physically interact with other people. We'd have no reason to declare our plans or to rely upon the plans of others. And we'll be forced to hold on to the resentment that we held for people beyond its expiry date, or always live within the shadow of our wrongdoing. So the world without normative powers would be an isolated and asocial world. And so in order to realize our non-normative interests or our autonomous capacities, we require a set of options, and these normative powers essential to facilitating these options. But this also means that to facilitate these options of interaction, of cooperation, normative powers need to have a conventional element. In other words, they rely upon representing a set of social tools, such as the practice of promise-making, consenting and forgiving, and these social tools rely upon a set of conventions or shared social practices. And it's in this sense that we can say that normative powers are morally discretionary. That it does not matter how these practices work, provided that they facilitate meaningful options, they facilitate worthwhile social interactions, and that there may be choices between different times and different places and different societies as to what the content of these normative powers are. So far, I've tried to introduce two main ideas. The first is that our normative powers of promise-making, forgiving and consenting are not reducible to our non-normative interests, rather than they act upon different set of moral phenomena. And the second is that normative powers function to coordinate interactions through the use of social convention and shared social practices. And that is why we have them, and that is the social tools they represent. I now want to turn to the second part of the paper, where I return to the pro tanto wrong thesis again. So far in our discussion of normative powers, we've talked about promise-making and how promise-making can generate primary obligations. We've also discussed how forgiveness can be understood as waiver, that it can waive or forego or extinguish remedial obligations. Throughout the discussion, I've presumed that consent is a bit like forgiveness, that consent is forbearing or wavering. But if the content of normative powers is somewhat moral discretionary, this might represent a choice. That we have a choice between two different conventions that govern our consent, that it might generate a primary obligation not to do something. This is what I refer to as the no means no convention. That through the communication of an objection, no means that someone has an obligation not to do something. Or it may be the case that consent is a waiver of a primary obligation, or the yes means yes convention. The idea that there is a pre-existing obligation not to do something, and that the communication of consent is the waiver or forbearing of that. Now, the pro tanto wrong thesis is essentially the affirmation of the yes means yes convention. That sex itself is a wrong that generates a primary obligation that is then waived by the provision of consent. Or as Stephen Shalford explains it, is a choice as to whether or not we presume that an adult is willing to have sex, even with strangers and unexpected encounters, until the individual specifically indicates the contrary, or should we presume unwillingness, even the settings of parties and dates, until a person signals receptivity to intercourse. And so the same question surfaces in the criminal law, that we have a choice between two different ways of constructing our criminal provisions. And here we have the orthodox view, which almost everyone subscribes to, and that reflects almost every criminal code, that the absence of consent ought to be inculpatory, since there's nothing wrong with sex per se. It is only the absence of consent that makes sex a wrong for the purposes of the criminal law. There are a few of us who subscribe to the alternative view, or the pro tanto wrong thesis. And there are three reasons given for suggesting that consent ought to be an exculpatory element. In other words, that sex itself provides a wrong that consent can then justify or excuse. Now, the three reasons are the reasons provided by Dempsey and Herring. I only agree with the first one. I consider the second and third to be too context-specific to build up a general or universal claim that sex is a face value or pro tanto wrong. But the first idea is that when it comes to least penetrative sex requires the application of force to a person, and I've suggested before that the application of force to a person is at face value inconsistent with their exclusive rights of control over their own body. And that gives us a reason to view the application of force in the sexual context the same as the application of force in the other context to a person, that it calls for a justification or is a face value wrong. Now we may wonder why this distinction matters. Well, it's because if we consider an interaction or the application of force to be a wrong that calls for an explanation, then the criminal defendant needs to at least provide that explanation. But if we do not consider the act itself to be wrong, then there's no need to question the actor's reasons for acting. And elsewhere I've explained why, if we consider sex to be a pro tanto wrong, then we need to engage in the defendant's practical reasoning, specifically the defendant's reasons for acting as they did and believing as they did, and how those reasons, that we call the explanatory reasons, relate or align to the accepted and permitted reasons for action, what we refer to as the guiding reasons. So the distinction matters, I've argued elsewhere, because if it's a pro tanto wrong that calls for an explanation, the explanation that the criminal defendant needs to provide needs to speak to the explanatory and guiding reasons that they acted upon. So that's the pro tanto wrong thesis by way of overview. Let me turn to the first main objection. The first main objection is that there's nothing wrong with sex per se. That if we're thinking in terms of generality or universality, there's nothing to claim about sex that's wrongful. And so there's a long list of commentators who will suggest that there are no reasons that are sufficiently general to ground the obligation not to apply force. So when it comes to actual bodily harm, Gardner has argued, well, that's unwelcome, even when it's consensual, and that might give us a general reason not to apply force to someone's body. But sexual intercourse, according to Gardner, is not an unwelcome turn of events, only becomes unwelcome when it is non-consensual. And similarly, Kate Greasley's recently argued that, well, there may be reasons not to engage in physical or sexual intimacy, but they are limitless and context-specific reasons, and that those reasons are too context-specific to ever generate a general obligation not to apply force. Now, I think both these claims are correct, but I think both these claims miss the distinction between normative and non-normative interests. So in light of the distinction I've tried to draw early on in this discussion, let me briefly respond to that first objection. I think it's true that when it comes to the morality of sex, it is informed by limitless context-specific reasons. As we've already seen with the help of Robin West's work, consensual sex can be harmful and denigrating, and consensual sex can be pleasurable or affirming. That depends upon a range of important context-specific reasons. The harmfulness of sex, or the worthwhileness of it, engages considerations well beyond our concern for consent can entertain. But also means trying to understand sex in general, sex per se, or sex itself, in terms of non-normative interests is a fruitless exercise. But the pro tanto wrong thesis is not concerned with non-normative interests, it's concerned with normative phenomena. It's concerned with the obligation, if it exists, that is a general one, not to apply force to someone else's body. As such, it's concerned with the role as consent as a convention that it can play in facilitating the expression of choice whilst opening up worthwhile options of social interaction. And so the claim from the pro tanto wrong thesis is a claim about the conventions that apply to our normative interests. And suggesting that it only depends upon when it's consensual, again, restates the question of, well, is it a forbearing or generating normative power? At the same time, we need to be mindful that the pro tanto wrong thesis is an argument about the criminal law. And so if we're concerned with this being a social practice, it is also a social practice that is a state-sponsored censoring and punitive practice. And whilst it may be appropriate for the Yes Means Yes Convention to be adopted in film scripts or sexual education programs or college codes, we have to acknowledge that's a different thing for this convention to be applied as part of the coercive arm of the legal system. And so I suspect that some of the concern or anxiety around the pro tanto wrong thesis is not so much that we shouldn't consider sex to be a pro tanto wrong, but we shouldn't be using the criminal law as a way of advancing the yes means yes convention. And I think that raises genuine concerns around culpability. So far, in terms of the commentary, there has been the willingness to tar the pro tanto wrong thesis with the claim that sex itself is just as culpable as existing criminal provisions that govern the law of rape. And so apparently I think that there are general reasons to avoid sexual penetration in all instances, and this means that it can pick out sex itself as being at the same level of culpability as the laws that currently govern rape and other sexual offences. Now, needless to say that, well, criminal culpability is only going to latch upon the finding of liability, and so we need not just the elements of the offence, in this context, penetrative sex coupled with intention, but also the absence of a justification or excuse. And under the pro tanto wrong thesis, it is the provision of consent that operates as a justification or excuse. And so I merely note that there are wrongful acts under the pro tanto wrong thesis. Here we have three options, the first two being recognised by both criminal codes. And I merely note that the third category of where penetrative sex occurs, where the defendant cannot show that they act upon explanatory reasons that relate to the relevant guiding reasons, in other words, where they cannot provide the explanation that sex itself calls for, that may be a culpable wrong, but it's not to say that those three activities are equally culpable. The existence of more culpable wrongs, 1 and 2, does not preclude the recognition of 3 as also a culpable wrong. But I want to focus on the third main objection that's levelled against the pro tanto wrong thesis, because it's both interesting and challenging. And that is the claim that there's nothing regretful about consensual sex. And this relies upon what's called the remainders thesis, the idea that what is distinctive about justified wrongdoing is that its commission, even when it's justified, it remains to be regrettable. And Greasy has recently added that not only is consensual sex not regrettable, it's also not avoidable. We do not have reasons to avoid consensual activity. And so our intuition is that if there's no reasons to regret our consensual sexual activities, nor reason to avoid them, and if we accept the remainders thesis, then sex itself cannot be a pro tanto wrong. So let me just start by giving some content to the remainders thesis. Ordinarily, when a wrong is justified, we have reasons to regret the wrong in the first place. So, for instance, there is an exception to the general prohibition not to intentionally cause another person's death in circumstances of self-defence. But in such circumstances, the victim's life or their right to life is of value that is not cancelled out by self-defence. It is a loss of life that remains linked to be regretted even if it was justified. Similarly, in circumstances of duress, we may have reasons to drive recklessly or dangerously if we're rushing someone to hospital with life-threatening injuries. In such circumstances, there is still value behind the traffic laws that we have broken. They haven't been cancelled out by those circumstances. The driver is justified, but they may have reasons to regret the endangerment of others through their justified actions. In comparison, when we do want to cancel out a value, when we want to subtract it from the moral calculus, we do so by cancelling it out in the construction of the elements of the wrong. So, for example, the act of taking a book is only a wrong when it belongs to another person. So theft then is the intentional taking of property that belongs to another person. There's no reasons to regret taking a book that belongs to you because the value is being cancelled out by the construction of the wrong, the idea of taking something that doesn't belong to you. And the orthodox view of the structure of essential offences holds that sex is similar to the third example. There's nothing to regret about consensual sex because the elements of the wrong simply have not been constructed. Now, there are two options for those who subscribe to the pro tanto role thesis. The first is that there's nothing really, there is linked to regret, that we could embrace the implications of the remainders thesis. And part of the reason why some people do this, Michelle, Madam Dempsey and Jonathan Herring do that, is because there are a range of reasons, some of which are context-specific, non-normative interests, that are not cured or resolved through the provision of consent. And so when it comes to, say, the risk of physical harm or the negative social meaning that sexual activity can have within a society or a culture, these are not removed or resolved or addressed through someone's provision of consent. And that's because when we permit or we consent to an activity, that doesn't alter the reasons against the action. The reasons against the action carry on. Consent merely removes the secondary layer of special protection around those reasons. And so the general understanding of permission is that it's still going to harm those interests. So we might view consent to a pro tanto wrong to be something we regret. Let me now try to avoid the implications of the remainders thesis by drawing upon the distinction I introduced between non-normative and normative interests. Now, when it comes to our non-normative interests, the interests we have in controlling our physical environment, consensual sex is not going to change those interests. Consent as a normative power is going to act upon normative phenomenon. We also know that consent as a normative power cannot address the all things considered moral situation. So there may be reasons to regret consensual activities because the normative power of consent can only act upon the normative phenomena of rights and obligations. And that is why if there are social or cultural stigma or negative connotations that calcify around sexual activities, as Dempsey and Herring identify, consent is not going to cure them. But when it comes to our normative powers, the idea I started with, the ability to change our normative situation, I suggest that consensual activity does not harm a person's non-normative interests. And that's because these normative powers are transformative. Recall forgiveness, the ability to waive obligations that are otherwise be owed to us, or promise making, the capacity to generate obligations that would otherwise not exist. In the same way, the provision of consent is transformative, that whatever reasons were explaining why there is the power to exercise consent, transform or change the provision of consent without leaving any kind of moral residue to regret. So in terms of trying to understand the regret or moral residue that comes from justified wrongdoing, I suggest that consent is different from the other types of justificatory defences that we might have. That we have reasons to regret the circumstances we find ourselves in. We have reasons to regret that our life came at the expense of the life of another in the context of self-defence, or that there's a trade-off between risks of injury between someone rushing to hospital and the risks we created for other bystanders. But that's a relatively morally static scenario. Consent creates a scenario that is dynamic. That the provision of consent is morally dynamic to change the normative circumstances of the activity without there being any residual regret, because it is the ability to act upon normative phenomena of obligations and roles. So finally, let me move to the three questions I set out to answer, because I haven't answered them explicitly. In terms of the first question, are normative powers reducible to our non-normative interests? I would suggest that we have a standalone interest in controlling the normative phenomena, namely the obligations that we owe the people and the obligations that people owe us. And this stems from the conventional function normative powers, that is to open up worthwhile options for us through a shared social practice. To that end, this means that the normative powers may depend upon social conventions, and that there are choices we can make about how those conventions operate. The conventions are not grounded in the raw morality of the situation, but we have a choice between, in this case, the yes means yes convention and the no means no convention, that the more fundamental morality of sex is not in question. And can we justify pro tanto wrong without residual regret? I suggest that we can, because consent as a normative power is an exceptional or transformative form of justification. It transformed the normative situation to render something that was impermissible to be permissible, and that the reasons generating the obligation are also transformed in that way as well. It cannot cure the entire moral situation, but it can enable us to change obligations that would otherwise be owed to us. So hopefully in this debate between orthodox and the unorthodox position, that our understanding of consent as a normative power gives us more resources to defend the claim that sex itself is an act that calls for justification. Thanks.